situation that the FEC decided fell within the so-called McCain-Feingold law, and it came to the court, which could have, following the well-established doctrine of constitutional avoidance, held for Citizens United on very narrow grounds, that it really didn't fall under the net of this law, but instead, even though the party bringing the suit hadn't raised the constitutional issue, the court on its own decided to set a rehearing addressing the constitutional issues in the Ornstein case, which is the most explicit decision on the ability of government to regulate corporations' expenditures in federal elections. So now, without any trial court hearings, without any evidentiary records, you have a court primed to make a decision that would effectively negate a century of campaign finance regulation. If that isn't judicial activism, I don't know what is.
Do I get a follow-up, or am I done?
Sure, absolutely.
Well, I mean, considering that these that if these groups are private or not, then how can then how can we judge that any of the previous legislation or rulings putting restrictions on them on private entities would be constitutional, and this one would just correct the record? Because I mean to say that yeah, there's been laws passed and past rulings saying that yeah, you can regulate them. What is there to say that maybe those were unconstitutional?
Well, I just think prudence. Now I know the ACLU has a absolutist position on this, and have fought virtually every form of campaign finance regulation, who believe that sort of money is equivalent to speech, and anyone who hopes to sort of channel or limit the role of money in politics is engaged in policing speech, and therefore it's to be avoided. But what I would suggest would at the very least be an orderly process of review with, the Supreme Court doesn't decide on its own what it's going to take up. We have a provision of the Constitution that has to do with cases and controversies. They don't out of whole cloth say, we're now ready, we now have the votes, with Sam Alito on the bench replacing Sandra Day O'Connor, we can wipe out all of these decisions. Let the process develop. Let a claimant come forward. Let it move through the court system. Develop a trial record. Bring transparency to the process. Let the country know what's going on. And then, if they're prepared to take that step, they have the right to do so. And we'll see over the course of time how that plays out with the American people. But the way in which it seems to be done seems to me an abrogation of, if you will, regular order. That's offensive to me.
Let me add a couple of things. The first is I find it offensive in other ways. This is really a Supreme Court that talks a great game as being strictly constructionist and following the Constitution, which means they pay great deference to what Congress does. If you look at the campaign finance laws, they were a model of how you want a legislature to act, spending a great deal of time building a historical record, looking at the facts, looking at how realities had changed on the ground, writing a pretty narrow set of provisions and laws. And that's what the court held just a few years ago. The people who are most eager to overturn this are those who are showing absolute contempt, and that was true in the argument, the oral argument, for Congress. So it's got even more implications than just deciding to step in and overturn 102 years of established law and constitutional rulings. then I think it's worth making a point about just the whole nature of corporations. And if you look back at the Austin decision and at earlier decisions, because it gets to the question of what the First Amendment means. Is it about individuals, citizens in the country? Is it about profit-making corporations? And in effect, what courts have looked at as they've examined this carefully in the past is that individuals have many motives when they spend money or if they speak, when they vote in different ways or express their preferences. Corporations have one, and it is by charter. It is making more money. So that's a part of the reason for not including corporations as having the same protections under the First Amendment in these areas. Another, of course, has been the rationale for most campaign finance laws in the past, which is corruption, preventing corruption. Well, go back to that Gilded Age. The evidence of corruption was overwhelming. And look at other instances in the recent past where we've had corporate funds used to finance political conventions, for example. The shakedown by political figures using the powers of the state, telling corporations that if they don't pony up hundreds of thousands of dollars, they'll face consequences in the legislative process, make it very clear that if we open up these floodgates, we are distorting the democratic process. So there's ample reason constitutionally for these laws.
Okay, next question,
Thank you.
please. Thank you.
Actually, just playing on what you were just talking about, one of the rationales, and the key rationales for one of the most transformative aspects of election law, which is the ability for any of us to look up who's donated to whom and how much. We've got limits on how much can be donated, but you've got donations to congressional and senatorial PACs, which can be very significant. That enables, the theory behind that was you don't want too much money driving an election. But the reality is that money doesn't drive elections at the congressional level anywhere near the way it does, say, at the Senate or the presidential level. 95% of congressmen get reelected simply because their districts are so gerrymandered and because their parties have control of, such a large number of seats. So the amount of money that a congressman gets from in contributions is not really affecting their ability to get elected, but it's affecting other things for which raising money is important. And now I'm wondering, just for your opinion, of the fact that we can see who's donating how much to whom, whether or not this is actually creating the kind of the opposite effect that you're describing, where congressmen can see who is donating how much to whom, and that may be contributing to the fact that most corporations and many individuals who have an interest in legislation are donating to both parties, and they're donating a lot and more money to both parties because that's how they can get heard. It has nothing to do with getting elected, but it has everything to do with getting heard and getting an audience. So I guess the question is, doesn't this level of transparency actually work against the people in a way that wasn't intended? And isn't that an unintended consequence of that transparency?
Well, there is a well-known proposition to reform the system by having contributions be anonymous, combined with a set of other changes, the Patriot Dollar, to empower individuals. It's an interesting argument. I think the whole direction within American society and as well as around the world now is in spite of the problematics associated with it, the transparency and in all of its dimensions is the sort of best disinfectant. You can see that now with efforts with the digital possibilities of getting dimensions of governance and reports out. I have to tell you, because of the availability of drafts of legislation, memos, and then blogs accessing them, we are getting really intelligent commentary made and then available to policymakers and to broader publics. I, in general, support the transparency. I think there are all kinds of problems, both practical and theoretical, associated with anonymous contributions, and so I don't happen to think that's a very promising arena. But I'd even take exception to your empirical assertion about money being unimportant in congressional elections. It's quite true that most congressional districts are now strongly Democratic or Republican. By the way, gerrymandering is not irrelevant, but it's not the prime driver of that. It has to do with the sorting of individuals into areas with like-minded views, because you see, you have the same thing happening in geographical areas with no redrawing of lines, like Senate, states. So it's also the case there still are about 75 to 100 competitive congressional districts where money makes a substantial difference. And I guess the concern with respect to this case is, gee, if a member of Congress knows that, let's say part of the final provision of the health reform bill is that you're going to put a tax on medical device manufacturers, which is part of the chairman's mark of the Finance Committee, and the medical device industry sort of lets it be known that they intend to engage in, for any competitive member in a reasonably competitive district, they will put $5 million into the campaign against them next time around. Or $20 million. It might get their attention in a way that, isn't, we'd rather have they ought to be able to speak and lobby and so on, but should they be able to use their corporate treasury in that fashion? I don't think so.
Yes.
Hi, I'm from Austin, Texas, and just to first chime in on the debate about ethics reforms. In Texas, campaign reform and ethics reform is still a constant struggle. There's currently no limit at all. And even though lawmakers are required to report the campaign contribution to the Texas Ethics Commission, those reports are incomprehensible most of the time to the public. And to just see the numbers sometimes don't really make any sense. And so it is still very hard for the public to really comprehend the link between money and the role that money plays in, per se, Texas politics. And that brings me to a more general question, which is, throughout the whole conversation, you mentioned a lot about the notion of honor and dishonor for the Constitution, for the House of Representatives, for the presidency. And it's a very fundamental concept, the notion of honor for our institution. The challenge is, nowadays, how do you instill those values of honors practically? When, in terms of debate, it's very fundamental, I think, because you mentioned it a lot, and those values are important in order for the Constitution or for the daily operation of Congress to even function. But practically, when there's debate, how do we maintain those values? And then the next question is, what is the role of the public in this whole discussion? You mentioned a lot about Congress and presidency and that sort of internal operation. And you referenced to this external environment, this cacophony of voices, angry voices and populist rhetoric that challenge that debate. So how should then the public filter out or sort out all of these things, and what's our role, the public, the general public?
That's a very good set of questions. One of the things we're struggling with now, I believe, is to find or recreate a public square. When you have vigorous debate, as is necessary in a society when you're making difficult choices that are going to disrupt people's lives, and you have a process where, as the framers designed it in a very different era, but as they saw this extended republic, it was debate and deliberation and face-to-face with people, but in other ways where you could incorporate other people's viewpoints, see that they've got a difference with you, but it may stem from the fact that they come from a an agricultural area or a particular group of people so they're going to have a different perspective than yours, and you work it through. But as we think about the public end of that, it also first requires that you have a common set of facts to start with, in which you can then have dispute over what direction you move in. And we're in danger of losing that common set of facts in this modern communications age, where it is very easy now simply to turn to a set of voices who repeat what you want to hear. And we know from some pretty good public opinion research that people who watch Fox News compared to those who watch MSNBC have very different views of reality. They don't start with the same facts. How we do that in an age where broadcast audiences are dwindling, where the broadcasters themselves, trying to compete against cable, decide to go as much for shock value and bring on people at two ends to do infotainment mud wrestling rather than anything else, where there are no authoritative voices that most people listen to, makes a real challenge for a political process. Now, you could look at another level as well, and talking with some people from Britain and Canada who watched the Joe Wilson thing and said, God, we have far worse things than that said in our parliament every day to prime ministers. The difference between a parliamentary system where you have a different kind of debate and ours is very significant. What we're now struggling with is a Washington which is operating more like a parliamentary system, but that's like trying to push a square peg into a round hole. And how you can make this work while preserving some sense of legitimacy of institutions, and then filter that into the outside where we know that you've got to have some broad bipartisan leadership consensus if you're going to affect major social change. And you've got to have some level of trust between institutions when you hit a crisis point and you have to delegate authority to a Treasury Secretary, to a president in different ways. If you lose that legitimacy, or if you can only